All right, so welcome into BUL 3130. We are going into our third week. This is going to be your lecture for Chapter 6, Criminal Law. This will be one of two lectures I'll be posting today. The other will be going over the next case study, walking you through that process a little bit, talking about maybe some of the hiccups that may have happened. Just a couple of things that happened with that first case study, almost non-fail. So we'll go over that, but first we're going to go into criminal law, talk about it a little bit. For the majority of the time I've been doing this class, when everyone turns in their final survey that I give out, not the one the school does, but the one I do that'll show up the last week of the term, it is your chance to tell me kind of what you thought about the class. And for the most part, this has normally been the favorite section for most students. And I think that's because it is something we can grasp. Criminal law makes sense. We see it. We see it in action. And it's one of those things that we don't have to like take a leap to understand. Where some of the stuff in law, you kind of have to step out of your comfort zone, learn a new concept, and kind of get an idea of what's going on. Criminal law, along with what we'll be doing in the next week with torts, they're around us. We see those, whether it's through television, Hollywood, personal experience, hopefully not with criminal law, but we're used to it. We see those. And so it's one thing that's fairly easy to grasp. And so what I want to do is go through the PowerPoint, just kind of go through it a little bit so we can see, what goes into the criminal side of things. We're going to talk about what the nature of crimes could be. We'll discuss white collar crime a little bit because that is a business crime, crimes against businesses, what some of the defenses to those can be, and then a quick look at what criminal procedure goes into. So when we think about crimes and what comes with a crime, the nature of those is real simple. When we have a set rule for society, we have a law that is in place. It has gone through the process. It's gone through the legislative process. It has made it through to a head of state, whether that be a governor, a president, whatever. It's made it to the point to where it's now the law for all citizens. And when we have a law for all citizens, it means all citizens are bound to obey it or commit a crime against society. So against everyone else who is supposed to follow this law. When we do that, we then can face consequences that come with that. In criminal law, it can be anything from fines all the way up to imprisonment. And in the state of Florida, in some other states, we have capital punishment. So it can go as far as being put to death for certain crimes. And so when we think about what criminal law is, we think about how that flow happens with the criminal process. The first things that have to be kind of ironed out and decided are whether or not we have the elements of a crime. Those essential elements are your actus reus and your mens rea. Most people are familiar with mens rea, the guilty mind. Hollywood likes to use that phrase. They like that little Latin phrase, mens rea, the guilty mind, the criminal mind, whatever it may be. But the actus reus is also important for us because we need to understand that just because you're thinking about a crime, we haven't made it to that Minority Report yet. For those of you who may have seen that movie many years ago, we haven't made it to that point where we're prosecuting people based off of what they think they may do. We need to have an act. We need to have action that goes with that guilty mind. Now, a way to look at this is you have the act and the guilty mind, the mens rea, is going to be where intent comes from. And intent is kind of that part of this that just keeps it all going, finding the intent. In a lot of law, no matter what the type of law you're studying, criminal law, torts, when we get to contracts, and other parts of law, it is the intent of the person who is accused that the court puts a lot of weight on when it comes to intentional cases. The intent or that mindset of committing a crime, the criminal intent is what we're looking at. Now, these pieces need to be in place for a conviction to happen. Now, there are times when you have a strict liability crime, which is the case, and we'll mention a couple of those a little bit later. That intent is not so much doesn't carry so much weight, but in most cases it carries a lot of weight, and we want to make sure that we are uh, understanding that having the intent, even as much weight as intent carries, still not enough if we do not have the crime. Uh, there are times when a lot of us may have, I won't say all of us, but a lot of us may have some type of criminal intent in our heart, but we do not act upon it. And that is what separates us from being charged with a crime and just being guilty of maybe not, thinking the best way in what we should do. So once we get past that, we've decided that we need the act and we need the criminal intent. We need to then understand what types of crimes we face. In most states, you follow a pretty similar pattern. State of Florida, we have misdemeanors and felonies. Misdemeanors are our lowest degrees. You can get a misdemeanor that is based upon something real simple. There are a lot of misdemeanors on the books that do not even get enforced because they've been there for so long. They're not something that is enforced. There are still places where spitting on the sidewalk is a misdemeanor that doesn't get enforced. And that stems back from the old days of when sidewalks were not laid with concrete. They were board sidewalks and they were attached to the storefronts, and store owners were getting mad about people spitting tobacco on their boards and staining the boards. It goes way back to things along those lines. So that is where, some misdemeanors are at. Now, felonies are a lot different. Felonies carry weight. They have seriousness to them. Now, not that some misdemeanors are not very serious. There are some misdemeanors that should probably be felonies, but they still carry that. But a felony in itself is where we get to the point of we start seeing incarceration happen with it. Someone who is guilty of committing a felony could get time in a county jail, or they could end up with time in a state prison system. For the purposes of the state of Florida, if you get a year and a day, so 366 days sentence in prison, you automatically carry into the Department of Corrections and not so much the counties. But that's going to come with felony. Vicarious liability falls in with this. It's imposed for the acts of employees if they're directed by an employer. So those can carry that too. If that employer knew that what was going on, they were directed, they participated in, or they approved of those acts without repercussion, then that is something that goes with that. The liability of a corporation that comes into play. Under certain circumstances, corporations can be held liable. As we've progressed really and truly in the last 20, 25 years, we have seen a lot more of this type of liability come into play, to where not only are we holding the criminal their self responsible, we're looking at an employer, and then we're looking at the corporation they work for. Who here needs to be held? Is this something they were directed to do? Is this something that the corporate headquarters knew about, or the corporation knew about, that they should have stopped and they did not? In criminal law, it is possible to charge a corporation with a crime. Now, you can't imprison a corporation, but you can take steps to make sure there is a true punishment there. One of the things that you look at, and we'll look at this a lot deeper next week when we look at torts, but one of the things that we want to look at is the ability of corporations to be treated as an individual under the law and be brought up on charges, or to have charges brought against them. All right. So when we think about that, think about Walmart. If Walmart had employees that were doing illegal activities, they knew of these illegal activities, there is the possibility that charges could be filed against the corporation Walmart. So when you think of the gravity of charging a large corporation that is everywhere, not just the US, but everywhere, then there's something we have to think about, that this carries a lot of weight when it comes to uh, corporations and their status in law and how they're treated constitutionally. They can be treated that way and charged with a crime, but they also get defenses the same as we do based upon the Constitution. So the personhood of a corporation in almost all instances mirrors ours when it comes to the Constitution. Right. So when we learn what the crimes are and we know what types of crimes, levels of crimes, and without going into real specific crimes, keeping this as broad as we possibly can, let's think about what defenses are. Now, the defenses to these crimes will narrow it down some. We'll get a little bit smaller, a little bit more narrow as far as what we're looking at. So, a defense to a person or property. The defense to a person or property needs to be shown and proven with that defense that there was not any other alternatives. You can use reasonable force to protect yourself, others, or your property. What is reasonable force? Reasonable force, by definition, in most cases now, once again, there are always these exceptions. You probably heard the old adage, there is an exception to every rule. That rule itself is its own exception type thing. So when you think about how crimes work and defenses, remember there's always some exceptions here. But barring those exceptions, the reasonable force that can be used, and this applies to a lot of law enforcement instances and others that work within the criminal justice system, it is to the level that the person is using plus enough to protect yourself. So if someone is threatening your life and there is an imminent threat to your life, now you have to think about what an imminent threat is. I weigh roughly 270. I'm a big guy. And if someone 110 pounds comes at me, is there a threat based upon that? Now, if I add elements to it, they have a knife, they have a gun. Uh, what is where am I at then as far as the level of threat that I'm perceiving? And your level of threat that you perceive in something like this may not be enough to truly be that defense of a person or self-defense. But when these cases come up, it's important for that to be in place. Duress is another defense. Now, this is a defense to almost any crime except for murder. You cannot say, well, I was scared they were going to harm someone if I didn't kill this person. You're still going to be charged with murder and likely found guilty based upon your confession. So that is, one of those areas where you have to think. Now, those are the extremes. Okay, those are the real extremes. Most of the time in business, we don't have to think about those. But those are the extremes. We are looking at criminal law, and not specifically just for business, but criminal law in general. So those are some extremes to it. Some of the others could be a mistake of fact. There was a reasonable belief that the conduct was not criminal. Now, there was a time when this would have been a lot easier than now, when we have easy access to anything we want to look at. Something seems sketchy, look it up. Is this wrong? Is this something I should be doing? Or just use the right way of thinking. If this doesn't seem right, it's probably not right. So avoid doing it as much as possible. So reasonable belief is a defense to it. Entrapment and inducement by law enforcement officials to commit a crime. That is one that has been around for a long time. Was used a lot during the days of them prosecuting the La Cosa Nostra, Sicilian Mafia. When they were doing those type of things, that was big with that. They were, entrapping, and then those that they didn't entrap were claiming they were being entrapped. And so there was a lot that went into that. But it's an inducement by law enforcement to commit a crime by an official that's part of law enforcement. All right, so those are some of the defenses. I'll let you catch up real quick in case you're taking notes there. These PowerPoints are always available on Canvas. So you go into the module that says PowerPoints and you can pull any of these up by looking at that. So next thing we want to get into, of course, is criminal procedure. So what is that? What is criminal procedure? What is the process that we go through? We've probably heard of due process. What is that process? What's the procedure? So each state and the federal government, they all have a way of initiating and coordinating their criminal prosecutions. There's certain ways they go through that. We have the first 10 amendments that are the Bill of Rights that guarantee us some defenses and to the rights of the accused. They come from there, or Miranda rights, things like that. We'll go over those here in a second also. But we're protected through that. Now, there are the 10 amendments, they're the Bill of Rights. They're also a bill of protections from governmental interference in your life to a certain extent. And when you think about the ones that apply to criminal defense and criminal procedure, they truly are a bar from interference to a certain extent. Let's look at the four that really kind of go into this, and then we'll dig into them just a little bit. We're not going to spend a lot of time with these. You already had a section on the Constitution, so we're not going to spend a lot of time, but let's just tie these four in to how they apply in criminal procedure. The Fourth Amendment, this is your unreasonable search and seizure section. All right, so that you cannot be searched without a warrant that has been duly sworn. The swearing of a warrant comes from law enforcement filling out an official form, an affidavit, giving it to someone within the justice system. It's going to be a judge to sign off on it. The judge approves that warrant, then the warrant can be executed for them to create a search in that way. The warrant, the Constitution says it needs to be specific to the people or the persons, to the place in those cases. So they're not like, here's a piece of paper that says you can go search everything you want to search anywhere you want to search. They're very specific. And it's designed to be that way to keep someone from being prosecuted that maybe was not the goal, or from being able to go a back door and pull someone into prosecution or the criminal process without going the proper channel. So the directness of it is designed to be that way. For friends of mine that are in law enforcement, it could seem like it is a bar at times, but it is designed to make sure everyone is doing what we should do. The Fifth Amendment is our due process, which is the process you go through, how you go through this, what are the stages, what is everything that you're getting that you're supposed to get, what is due process. Part of due process is the right to an indictment by a grand jury for capital crimes. There are two different types of juries in most cases. You have what is considered a petit jury and then a grand jury. Petit jury is the one that we all get called to, go to jury duty, you go to your local county courthouse, you sit there and you get selected or not. You're going there for one case, that one case only, whether it takes a day or it takes a month. The grand jury is a little different. When you're calling to grand jury duty, you're going to sit and you're going to listen to the state present numerous cases, sometimes 2 or 3 a day, where they're discussing the case. They're basically presenting a mini version of the case they're building against a defendant or against someone who's accused. They're going to show that case. And what they're trying to do is get the grand jury to pass down an indictment. An indictment is not a statement of guilt. An indictment says that the evidence against this person is enough to take it to trial. And so they pass down the indictment. The state will then take that, complete the building of their case, and then take it to court and present their case in court. Grand juries do not decide guilt and innocence. They just decide, is this a good enough case to move forward with? The Freedom from double jeopardy is here, that you cannot be put in danger of life or limb twice for the exact same crime. Now, notice I am paraphrasing these. And then the right from self-incrimination. We've all heard this one for years. I am old enough to remember the Iran-Contra crisis and seeing person on top of person on top of person testifying before Congress and simply stating, I plead the Fifth Amendment, or I'm claiming the Fifth Amendment right. Whatever it may be, they were claiming a right not to say anything that could cause them to be incriminated in a crime. And so they were doing that to protect themselves. The Sixth Amendment is where we get the trial process. You have the right to a speedy public trial by jury, the right to be informed of accusations, the right to confront witnesses, to present witnesses, and to competent counsel. I love that competent counsel part. If you ever get in trouble, make sure you have that. But let's break down those for a second. The right to a speedy public trial by jury. Speedy trial may not always be in the defense's best interest, so it is a right that gets waived oftentimes. It gives them time to build a good defense. Trial by jury. My take is always this: you have a choice of a trial by jury or a trial or a bench trial, which is the judge himself or herself questioning or deciding your fate. I always like to bring in the adage, okay, I could take my chance with 12 or with one. That judge could wake up and first thing in the morning, get out of the bed, stump their toe, go in the bathroom to brush their teeth and grab cold cream instead of toothpaste because they were still blurry eyed from stumping their toe. They go to make their coffee and spill their coffee everywhere. They get stuck in traffic on the way to work and they're running 15 minutes late. And then they come in and they've got to hear you try to tell them you did not do it. The chances of 12 people sitting in a jury box having that exact same bad day altogether is not super high. And so I'd rather take my chances with 12 than one. That's just me. That's a personal preference, but I always like to throw that in right here in this part. The right to confront witnesses. We know that both sides can call witnesses and they can confront the witnesses for the other side. We have that's your examination and cross-examination in the process of a trial. And then the right to competent counsel. So what I want to do here is put the Fifth and Sixth Amendments together, and you have the Miranda rights within those two. So the Miranda rights, which was brought about by Miranda v. Arizona, the Miranda rights with a few different, differentiations here and there are: you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have a right to an attorney. If you cannot afford an attorney, one can be appointed to you at the cost of the state. Do you understand these rights as I have read them to you, or something similar to that? That is the right to, or the freedom from self-incrimination in the Fifth, and then the right to competent counsel in the Sixth. Came about because Miranda, the person who they're named for, was not aware of those type of things, was not aware that they needed to stop talking, was not aware of, quite a bit of the rights there. And then we have the Eighth. The Eighth is freedom from excessive bail and freedom from cruel and unusual punishment. These specifically have to do with, for the most part, have to do with the criminal justice system after trial. Cruel and unusual punishment, when we think about that, a lot of times we tie it to those that are incarcerated. Excessive bail is that process when someone is waiting to go to trial. So these are post-arrest and sometimes post-conviction type of issues that arise there. The 14th Amendment ties them into the state, which says the state has to follow these. So we have the 4th, 5th, 6th, 8th, and then the 14th to make sure that states are doing that. All right, so within criminal procedure, let's think about what those steps are. You have the arrest of a suspect. They're brought into the county jail, wherever, city jail, and they're booked into jail. At some point, they're going to be taken in front of a judge. They're going to be given a formal notice of whatever charges are brought against them. There's going to be preliminary hearings that could be the setting of bail. They could be determinations of information, a chance to enter a plea. They can have an arraignment, which covers a lot of that. And then, of course, the trial, which will happen once all that has taken place. So I'm not going to go through each one of these intent because we did go through them already. We will talk a little bit about the search warrant again, just to reemphasize that the Fourth Amendment prohibits those illegal searches and seizures. If it's obtained outside of that, that is when defense attorneys will fight to have that evidence excluded from the trial. The appeals process that happens in certain cases is tied to a lot of times the wrongful introduction of evidence or things tied to these rights, the type of rights that a person has when they're going on trial. So it's important for the state to follow the rules that need to be followed, for the court to follow the rules the court is supposed to follow, so that there's not a chance for an appeal, even though appeals will still be filed, but it's a better chance for the conviction to stand and be upheld by the higher courts. So there are times when there's not necessarily a need for that search warrant in the criminal process or the criminal procedure. Those are listed here on this table. The table's in the book, and it's also on this PowerPoint that you have access to. So I won't spend a lot of time going through it. You can read that for yourself. Most of these are pretty, common sense type things. Hollywood's favorite one to use every time you watch a cop show is the emergency or exigent circumstances. The knock on the door, it's police. They don't get an answer. They go, "Oh, do you hear someone crying out for help in that room?" And they bust the door down and go in. Real life, you need to make sure that you can prove there was someone in trouble on the other side of that room, or at least you had a good, true belief that someone was in trouble on the other side of that door. So things like officer safety, incidents to a lawful arrest, those are searches that are done. Clothes pat searches, things along those lines. Consent, giving law enforcement consent to search your car, your home, property, whatever that may be. One thing I told my children when they were learning to drive and starting to go out on their own at times was be careful when you're giving consent. If you've had any of your buddies riding with you, how well do you know that buddy? Did he have something in his pocket that he let fall out of his pocket in your car? And then it's in your car that's assigned to you. And when they stop you, they're going to look and see what do you have, not what your buddy left in there. And there's not a defense that states my buddy left it in here, it's his. So being real careful with that is truly important. Once again, the Fifth Amendment and that Sixth Amendment. The Sixth Amendment is designed for transparency within our court system. And so criminal proceedings go and everyone is aware of what's going on. The whole process of going to trial and everything that happens in trial, there is a piece of that that's called discovery. There's a whole timeline within the trial process that's called discovery. Discovery is when both sides are exchanging information so that no one is surprised by what is coming and everyone is aware so that a proper defense can be built. It's all about being able to defend yourself and being able to prove you're innocent if you're truly innocent. And that's what this procedure and the parts of the procedure that we cling real tight to or build upon, having the attorney, having the right to confront witnesses, being able to know what the other side has as far as information goes. So it's important that the procedure is followed, that due process truly does work for you. All right, so as we move on, let's talk about some of these white collar crimes. And we'll talk about these. I won't spend as much time talking about some of them. The very first one here is one that hasn't been around for a long time. There have been computer crimes for 40 plus years, but we really and truly hear about these a lot more now. People were hacking way back. There was a movie made when I was young, War Games. Matthew Broderick was in it. He was a computer hacker, hacked into the defense and was playing war games with a defense early version of an AI, and it was playing war games with him and almost launched a missile strike till they played tic-tac-toe and came to a draw. You haven't seen it, check it out. It wasn't a horrible movie. But that's where computer crimes have been around for that long, but now we hear about them a lot more. And they're used more and more, not just as in criminal ways, but also in ways that countries are using them. So the use of computers has pushed us forward greatly in progress and the ability to get stuff done and knock out tasks real quick. I'm recording this on a computer. The PowerPoint was created on a computer. Everything we do just about has that, but it's also made a reason for us to have new crimes and new defenses and new prosecutions for these crimes. So with everything like this presents, there's always that side of we need to make sure that we're keeping everything in check. And so as we progress, so will the teaching of criminal law and how criminal law progresses. RICO. RICO is not as common now as it used to be. It's used for a set purpose. It was initially introduced back late 60s, early 70s, as it was being kind of worked and put together to prosecute, once again, that Sicilian mafia. The reason RICO was designed and how it worked was if you've ever seen the boards that they put up showing a criminal organization where you have someone at the top, that pyramid going down. RICO is designed to bring all of them in at once, to put charges against every one of them and try to get each lower level to turn on the next level above them. The goal of RICO is to charge everyone with a criminal act as an organization and then turn each level till they can get to the top. The goal is to get as many of the top players off the board. And before RICO, they could arrest, the street thugs or whatever, but they could not go after those top guys because they were just almost untouchable. But RICO allowed them to be able to do that. Now, since its inception, RICO hasn't been used near as much for that type of crime. Only about 10% of the RICO cases filed since its inception have been mafia-style cases. Most of them have been business fraud cases because it just worked so well. It was built for a criminal enterprise, right? It was built to prosecute a criminal enterprise. Well, that criminal enterprise had a structure just like Walmart, Target, and Apple have. They have someone at the top and someone works under them, and it goes down to the workers. And so it works real well in that type of setting also. You have larceny and embezzlement. Larceny is taking and carrying away a personal property of another with the intent to deprive them permanently of it. Embezzlement is when you take the property of someone else. It was in your possession, but you use it in a way where you're not intending to use it. Embezzlement happens in businesses where someone is, they handle the books, they handle the numbers, and they put stuff to the side and choose. You also see this, unfortunately, in caretaker relationships where someone is charged with taking care of someone else. And a lot of times that gives them access to credit and debit cards, gives them access to bank accounts. And unfortunately, not everyone who is a caregiver is an honest caregiver. There have been cases in the town I live in within the last 10 years. We had a spree of those about 10 years ago where people were getting arrested for it. Thankfully, I don't hear about it as much now, but it used to be kind of common for someone who was watching, especially an elderly patient or an elderly client, and they would take their cards, go to the ATM, take out the money they needed for the person, but then take out, $25, $30. Well, you add up each time that $25, $30 can get a pretty large amount over time. I managed a grocery store, and the reason I became the manager of it was the previous manager of it had done something similar to that. As managers, we would take the deposits to the bank. Well, each time she would take a deposit to the bank, she would take a little bit out of it. Over the space of about 6 months, she stole $2,000, and so it became an issue where they had to make a decision there. They did not go the route of making it criminal. They just removed her from the job, but it was a case similar to that where she was embezzling from the company. You have false pretenses, robbery, burglary, extortion, making threats to obtain money and property. Robbery and burglary, most people kind of understand what they are. False pretenses, the name pretty much says for itself. Bribery, forgery, bad checks. We don't hear about bad checks as much anymore because I cannot tell you the last time I personally wrote a check. So we don't hear about that quite as much, but it does still happen at times, especially in your businesses that still use paper checks. All right, so let's stop the share on this, get back where my face fills up my screen. It'll fill up yours too, sorry. But the criminal law and its application to the business world is unfortunately one that we face a lot more common than we'd like to. And just as I was speaking about the computer crimes just a few moments ago, it has happened that way a lot because we're progressing and the mind progresses with it. And unfortunately, that has progressed to the point of us taking advantage of each other and doing that in a business setting, which is where a lot of these crimes come from. All right, so that'll do it for this lecture. Hopefully, you'll be able to get anything that you need out of this. If you have questions about it, please reach out to me. The next lecture that I'll be posting, if you watch this one first, the next lecture that'll follow this will be one based upon the case study that's coming up due in 2 weeks.